Yeah, fighting for public records has been my main thing. I mean, this court data is a public record, and it just falls neatly into the overall theme of public access to government information. Because, to know how your government works, to know how it operates, and looking at the judicial system, the criminal justice system, in particular, you want the system to be consistent and fair. And how do you evaluate that unless you have access to this kind of data? And if this information is only accessible to the court administration itself, only accessible to the county attorney, the prosecutors, it's not a level playing field. And so that's the battle that I've been fighting now on this stuff for the last 20 years.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing. Hey everybody, Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona, for another episode of Set for Sentencing. Today is going to be actually really cool. Our guest is a gentleman by the name of Rich Robertson. We've been talking about having him on the podcast for a very long time, and it's happening. It's all happening today. Hello, Rich Robertson. How are you?
Hey, Doug. It has been a long time.
And it's not your fault. It's my fault. I take full responsibility, but you're here now, and that's all that matters. So before we dig in, who is Rich Robertson? So Rich is the cream of the crop of investigators, not just in Arizona, but I would say probably in the nation. Rich was, back in his prior life, he was an investigative journalist. He worked for the big paper here, the Arizona Republic, and he worked for local news stations, and that was a full career, like 28 years, I think. And then he ends up in the world of criminal defense. I'm sort of interested in that origin story too, by the way. But he really is amazing. He's highly sought after. He really does have a national practice. And I think one of the coolest things in your bio, you said you were honored in 2017 by the Arizona Attorneys for Criminal Justice, which is our local defense bar, criminal defense bar, with the John J. Flynn Lifetime Achievement Award, the only non-attorney in the organization's 30-year history to receive that award. That should probably tell you all you need to know about Rich. But if you don't know who John J. Flynn is, of famed Miranda case, he was a legal luminary in the state of Arizona and beyond, and he, along with John Frank, litigated Miranda. And so to receive the John J. Flynn Lifetime Achievement Award is a big deal. Anyway, I'm so glad to have you here. Welcome. Yeah, give me a quick origin story. What happens? How do you get from investigative journalist to criminal defense investigator?
Well, after 28 years of working in the news media, I had gotten to the point where I felt like I just wanted to work for myself. And seems like a lot of journalists wind up as public information officers or something like that, or go to law school, frankly. And I toyed around with that, but this kind of came along in a weird kind of way. But it was I realized that the similarities, it's the same skill set: gather facts, tell a story, and that's what you do as an investigator, whether you're a reporter or a criminal defense investigator or an attorney. I mean, it's all about telling the story, and so that's kind of how I approach it. And this sentencing study stuff is an outgrowth of that. The nice thing about journalism, and what I liked about journalism, is you could always you went into a story looking for the 20,000-foot view, if you will. You're looking for systemic kind of issues that are surrounding a topic. In criminal defense world, we tend to narrow it down to our guy, and it's just this case in this time period in this courtroom. So And I looked at it, some of these, and said, let's look at it in a bigger context. Let's look at this case in the context of similar cases.
Yeah.
And how does the outcome of our case compare to other outcomes? So that's
I love
kind of
this.
where
So
it started thinking about these approaches.
yeah. So, and just to set this up a little bit more, well, first of all, story is music to my ears. You're singing my favorite song. It's everything that we do in criminal defense, and you know that well.
Right.
But when I was talking with Rich, like, okay, I really want to have you on. I really want to have a conversation, but it's a sentencing podcast, and I always in my own head, sometimes we need investigators for sentencing. But I always in my own head associated it more with pretrial and trial work, finding witnesses, interviewing witnesses, that sort of thing. And Rich is like, no, this is very much about sentencing. And what we talked about is this idea of, well, if anybody's heard me talk about my 3 R's of sentencing: storytelling, that's revelation stories, relativity stories, and redemption stories. And what we started zeroing in on is relativity, comparing this thing to that thing. And if you've been listening to this podcast, you know that, especially with our friend Mark Allenbaugh, who does federal sentencing statistical analyses, that is a massive component of sentencing advocacy. It's an often overlooked one because a lot of lawyers still don't know about this, but you have to take a 360-degree view of not just your client's case, but all the cases that are orbiting this universe to see, how's it shaken out over here? What is this judge doing? What is that court doing? And that helps the judge that you're actually in front of come up with a more informed and hopefully more just result. And so I didn't know that you were doing the same sort of stuff in the state context, and not only that, but in some really interesting cases. So let's dig into the big ones, which are these would you call them voter fraud cases? Is that the best? What a timely topic. So talk to me.
Well,
What are these cases?
even before that, if you would like, I can kind of give you some context of how all this started. This has been a 20-year deal, and I want to give a shout out to the guy who actually got me going on this. It was Judge Stephen Gerst. For those of you who've been around for a while, Judge Gerst was on the Maricopa County Superior Court bench, and he had a case in front of him that was a very high-profile case in Phoenix. It was the Bishop of the Phoenix Diocese of the Catholic Church.
Yes, I remember that.
Yeah, it was a big deal. Big Thomas O'Brien.
And what did he allegedly do?
He was driving and hit and run, killed a pedestrian. There was some allegations, of course, that he was intoxicated at the time, but he went home, and it took a while to find him with all the damage to his vehicle. But he was charged with leaving the scene of a fatal accident. And Judge Gerst presided over that case, and it went to trial, and a jury convicted him. So it came down to sentencing. And the sentencing issues, the prosecution and the pre-sentence reporters recommended a jail term as a part of probation. And they wanted at least 6 months of jail for the bishop. And of course, the defense wanted just straight probation. So the judges, you can imagine what the pressure would be like on the judge. No matter what he does, it's gonna be this guy was given a light sentence because he was the bishop of the Catholic Church, or he was given a harsh sentence because he's the bishop of the Catholic Church. It's like a no-win situation. That particular case, the day of sentencing was broadcast live. I had nothing to do with the case. I was a private investigator already at the time. So this was in 2004, I believe it was. And so I was listening to it just like everybody else. And what Judge Gerst did is he came out and he did a PowerPoint presentation in which he described how he had compiled 100 cases that had been prosecuted in Maricopa County for the same offense, leaving the scene of a fatal accident. He compiled 100 cases over the prior 5 years, I believe it was. And he compared them, and he compared the factors and the circumstances and the defendant, with no prior histories, that kind of thing. And of course, the outcomes of all those cases at the time, the presumptive in Arizona for that offense was 3.75 years. And the judge, found in those 100 cases, people from just getting probation to getting, lengthy prison terms. So where does this Catholic bishop fall in all that, and how do you compare them? So he took those 100 cases and he started doing his analysis and concluded that based on the outcomes of similarly situated defendants, that probation was without jail was warranted, and that's how he sentenced it. But he had this data to back it up. It wasn't it. It's E.J. Montini, who was a newspaper columnist, wrote about that, and he said that Gerst basically took the wind out of the controversy by showing empirically how he came to the conclusion of what the just sentence was. And a just sentence in this case is, and in every case, is kind of based on fairness and consistency. And so I'm listening to this while I'm driving my car, and I had two thoughts about it. One, where did he get the list of 100 cases? And two, why isn't this analysis being done for all criminal defendants? And so that started my search for the data, for starters, and a several years long process of fighting to get access to that data. So I've been doing this basically for 15, 18 years now.
That's amazing story too around that. But let's talk about that, because in the access element, because in federal court, access is, at least to the first level data, is pretty easy to do, because the Sentencing Commission has to put out this information, so anyone can access it pretty easily. I'm guessing not the same for various state, local jurisdictions.
Right. Well, it's not supposed to be difficult, but it is. And it's governed under the Arizona Public Records Law and Supreme Court Rule 123, which is the public access rule for court records. And so I've used both statute and the rule to go after this from county attorneys. You can use the public records law and go after the courts to get under the court rules. And access to bulk data is specifically mentioned in the rule, and so it's definitely there. The fight I've had has been more of an administrative burden kind of problem, which is not a justification under the public records law, but it's. The courts complain we've got so much work to do, and here's this guy out here trying to make us do more work. They'd rather do the work for the internal folks. So I get resistance, and I got sued actually by the Pima County attorney for having the temerity to ask for this data.
Wow.
From their office, and this led to a 2-year court battle that went all the way to the state Supreme Court. And it kind of boiled down to, or the excuse they used was, they tried to say that I had a commercial purpose and therefore they could charge me a whole bunch of money. But the statute and the rule is very clear in Arizona that using public records in the context of court purposes, judicial purposes, is not a commercial purpose. But the nuance aside, what they just didn't want me to have the data is what it amounted to. So through no fault of my own, I got sued and wound up having to litigate this through a trial court, appellate court, and all the way to the Supreme Court. And there's now case law in Arizona. I have the honor of being in a caption. So it's Lawal, Barbara Lawal was the county attorney at the time. Lawal v. Robertson is the case that has to do with the access to this data.
I did not know that. And
Yeah.
anybody who's from here listening probably knows that name, Barbara Lawal. She had a reputation down in Tucson
Right.
as being very special, a very special county attorney. We'll leave it at that.
That's right. I've had to fight with the county attorney in Maricopa County, a couple of county attorneys now, and Bill Montgomery in particular. I fought with him over this, and he's now on the Arizona Supreme Court.
Yes.
And
Which coincidentally happened on the eve of the filing of a bar complaint for his failure to supervise Juan Martinez.
yeah, I was involved in that case too. Yeah, it was. Yeah, that's
Well, that's a whole other
yeah,
podcast.
we could do that one for an hour or two, but so it's been a constant battle. You think that these issues would be resolved, but every time I file, I have to, the Arizona Supreme Court is a source of data on this as well, and I get that data. But I've had to fight with them over some requirements for insurance and things like that. And I think we finally got this resolved, and I get this data pretty regularly.
Sometimes I like to put a finer point on it because I do have some listeners who don't play inside baseball, and they're not lawyers or legal professionals. And I just want to kind of emphasize what obstacles defendants and their lawyers and their teams face every day that they shouldn't face, and why they face them, which is to obstruct our ability to mount a proper defense. All you're asking for, you're not asking for private policies or inside dirt on police or all the things we might ask for, and they might have a valid argument as to why. You're asking for public information about cases that have already been litigated, adjudicated, and are part of the public record, and they're still fighting you about it. And that, to me, should tell my listeners everything they need to know about whether this system is a level playing field, and whether the other side often has a focus on doing justice, or whether what their actual intentions are.
Yeah, fighting for public records has been my main thing. I mean, this court data is a public record, and it just falls neatly into the overall theme of public access to government information, because to know how your government works, to know how it operates, and looking at the judicial system, the criminal justice system in particular, you want the system to be consistent and fair. And how do you evaluate that unless you have access to this kind of data? And if this information is only accessible to the court administration itself, only accessible to the county attorney, the prosecutors, it's not a level playing field. And so that's the battle that I've been fighting now on this stuff for the last 20 years.
Amazing. Amazing. All right, so let's dig into some of the cases you've been fighting these battles on now. So you won that case. You got the Supreme Court case on your side. You're off to the races. You're getting this information. How's it helping?
Well, it helps in a variety of ways. So what happens is I get retained by an individual defense attorney who has a case, and sometimes it's a case where I'm doing the fact investigation as well as this component of it. So I'm assisting them on the outcome of the case, as well as trying to figure out how to gather all the facts that they need to figure out how to litigate the case. But other times it's just this component, and an attorney will come in and say, look, I have a client who is charged with these things. I want to know how clients with similar factors, what the outcomes were, what kind of arguments were made to get a preferred outcome. What is the difference between my client and somebody who got just straight probation versus prison? What are those factors? And there are so many elements that we look at, and the obvious ones are things like priors, the obvious things that go into these things, but also the extent of, we see differences in sentencing because of the extent of the injuries that the victim might have suffered. We see the effect of cooperation and remorse. We see the effect of race, gender, and who the prosecuting agency is. And one of the big factors that we find that we can quantify is victim outrage. the victim, how vocal is the victim's family or the victim himself in this prosecution, and that certainly affects the outcome. And we can show that where you take similarly situated defendants and you have one where there's very vocal victims versus not, and you can see that the sentencing outcomes are affected by that. So some of this is obviously intuitive. The attorneys know this, but what happens in many of the cases is we can pull this information so that the attorney can manage the client's expectations. It's even though we're using this to help in plea negotiations, sentencing memorandums, and I testify frequently in sentencing hearings about the studies I've done. But before all that, it's sitting down with a client, because as defense attorneys know, clients walk in with unrealistic expectations. Yeah, I know I molested that 4-year-old for years, but I'm really a good guy, so I think that I only deserve probation.
Yeah.
Well, the attorney can sit there and say, look, I've been doing this for 20 years, and trust me, that's not going to happen. And based on my experience. But if they can walk in and they ask me for the empirical study, the way Judge Gerst did, and just say, look, here are all the cases that were charged similarly to your family member, to you, whoever it happens to be. You can read this stuff and you can come to the same, conclusion about them. So often these studies are just used internally within a case to manage the client's expectations about the outcome.
Interesting. All right, let me back up because I'm curious about something. So you mentioned victim outrage. So what you're looking at first is just the raw numbers. What's the sentencing outcome? How many months or years, or was it probation? But then you have to go to the next level. If you've got a result and you're curious as to why that result was what it was, and in this case, you mentioned victim outrage is a factor, but how do you know? Like, what's the next level? What are you looking for beyond after the raw numbers?
Yeah, because you can go into the sentencing data and we get the basic court data, which is the case number, the defendant's name, what the initial charges were, what the outcome charges were, what the sentence was. But then we just start with that basic information, and then we dive into the court files themselves. That gets out of the database. Then we're down at the clerk's office, pulling each of those cases and reading the charging documents and reading the pre-sentence reports are valuable. Any sentencing memorandums, plea offers, all of the motions that are filed by victims, for example, victims retain attorneys, and so those are going to be in there. And so we start just doing an analysis based on the narrative and compile that stuff into just a complicated spreadsheet, basically. And then you can just start doing various sorts on it. And with somebody that was drunk driving and ran into somebody else, and it was a passenger who died versus the driver who died, or an occupant of another vehicle who died, or the ages. So we can kind of look and say, okay, in your particular case, these were the factors. Let's find all the other cases where the factors were the same, or similar, or even better, that were less harsh, that were less egregious, if you will. And so sometimes it's a comparison. It's not a one-to-one. Here's all the factors that were the same. But what happens to somebody who has a more egregious case or a less egregious case? And how is it that you're going to give my client 15 years where somebody that had more egregious conduct got less than 15 years? So we can look at those in a variety of different ways, and that's where the narrative comes in.
Interesting. That to me sounds like a lot of effort, a lot of work.
It does,
Just
and
just fighting the fight to get the access, going to the court files, reading all this stuff. I imagine you got to order some sentencing transcripts sometimes too. Like,
you do.
tell me
It's,
about the time, the labor
yeah,
intensity that goes into
intensity.
this
Yeah,
analysis.
yeah, it does become intensive, and which translates into expensive. I mean, it can be, $4,000 or $5,000 that we would charge for one of these things when they're like, and it really depends on how many cases we're taking a dive into. Is a dozen cases sufficient to make the argument you want to make? Is it 20? Is it 50? Is it 5 years? Is it 20 years? Is it just in Maricopa County? Is it statewide? So there's a variety of things that go into that. I've got one going on right now that where the defendant was sentenced in Mojave County for there was 22 residential burglaries. No crime victims involved here. There was no violence. These were property crimes, but there were 22 of them. This guy was,
That's a lot of burglaries.
He had a habit.
That seems like a lot to me, and I've been doing this a minute.
Yeah.
I'm not sure I've ever had a case with 22, but go ahead.
Well, and so he got sentenced to two consecutive terms for each of these counts. He got 292 years for property crimes. So now the question is, so we dive into the data and you want to look and say, okay, as you said, how many people get charged with that many? We can use the data to identify all the cases where, say, more than 10 counts or more than 20 counts, whatever we decide, and then look at the outcomes of that. And then we looked at that one in particular in contemporaneous to his. So what was happening with people who got charged with more than 10 counts of burglary, residential burglary, in the 5 years before and in the 5 years after his cases. By the way, his sentence was upheld on direct appeal because the statute allows the judge to decide whether it's concurrent or consecutive.
Yeah.
And so he had the discretion and he used it. But what we were able to show is that this particular defendant was the only one that's happened to. No one else in Mojave County has had that kind of outcome. And so now the issue is, what do you do with this data? In this particular case, it's going in front of a clemency board because the harshness of the sentence, the disparity, is an issue for the clemency board to consider. And since the appeals have failed on the legal issues, now it's a question of fairness. And so that's kind of where that kind of case is going. And we can look at that across the board. Some of these rural counties don't have as many cases, so you wind up having to compare it to Maricopa County. But that's kind of where it goes. The other case we got involved in some years ago, 7, 8 years ago, was the infamous case called Hidalgo, which was challenging Arizona's death penalty on the basis of the aggravators. This was a Furman analysis. So I was asked to assist the public defender's office. Susan Corey and Garrett Simpson took this case all the way to the U.S. Supreme Court. And their position was that Arizona's aggravating factors that make the determination of whether or not this is a capital case were so broad and so many that every first-degree murder case qualified. And everybody kind of knew that. Everybody had accepted that, but nobody had ever actually sat down to show that whether that was true. And so I was asked to identify all the first-degree murder cases in statewide for 20 years. And we pulled together, identified 890 cases, I think it was, 850 to 890, somewhere in that area, cases. And then had a bunch of law school students actually sit down with all the case files that we pulled together and went through the narratives to determine what the aggravators were in each of those cases, and found that 99% of all the cases could have been charged as capital, that it was covered, and therefore the aggravating factors are not limiting, and that was the challenge. It didn't narrow all the first degree murder cases down to the worst of the worst.
Yeah.
It always becomes a political decision by the prosecutors as to whether they're going to pick this one or that one.
Mm-hmm.
And so that shouldn't pass muster.
Yeah.
This went
And
all the
sometimes a
way.
financial decision too, right?
Oh, huge.
Some
Yeah. You
counties
can
don't
commit
have the resources to do death penalty.
right. You can commit the same murder in La Paz County that you commit in Maricopa County, and you might be facing death in Maricopa County, but not in La Paz because they can't afford to prosecute it that way.
Seems a little random. I would love to, again, put a fine point on the takeaway, because earlier when you said this is super expensive, my heart kind of sunk, because my initial fear is, okay, well, only private, well-resourced clients with private attorneys are going to get the benefit of the service. But then here you are talking about a major seismic shift in the way capital litigation is handled here and in Hidalgo, and public defender's office originated this work. So that tells us.
And we have done these sentencing studies for the public defender's offices, and contract indigent attorneys have sought our studies as experts. I mean, this is not an investigative thing. This is, you hire experts to do analyses of your clients and the clients' forensics on their phones and everything else. Why not on sentencing?
Yeah.
And so the public defender's offices have paid us as experts to do some of these studies for them.
And so, I have people listening from all over the country, hopefully. But I don't know if, hopefully they just hire you and you get to go all over the country. But if it's not, I just hope that people who are listening understand that, if you're in wherever Poughkeepsie and this has never been done, and you have to convince your public defender office or court to finance this, you should still go and get the data from Rich, so that people understand this is a thing. This is a process. It's part of criminal defense, and it's essential to criminal defense, and it should be funded. So people, it's like standing on the shoulders of giants at that point. And you're the giant. So hopefully people will reach out to Rich. I've got his website in the show notes. And what is your website, by the way? First plug.
It's R3 Investigations.
R3 Investigations.com. Thank you.
Right.
And if you can't hire Rich, at least have him do an affidavit in your case to say, this is a thing and it needs to be done here, and here's why. Okay.
Yeah, and I haven't done these outside of Arizona because the data access is different in every state. The rules, the laws, everything else, and so and obviously our practice is here. So fighting the battles to get the data to start with is just the first step, and so to do a one-off in New Mexico or something doesn't make a lot of sense. But I've been advocating this to investigators and others in other states to look at their particular state and carve out that niche in their state. To my knowledge, I'm the only one doing this in Arizona.
Wow. I'd love to at some point down the road to see a national sort of network where you could say, yeah, so-and-so, Mrs. Joe Blow in this state's doing this stuff. And then even a database at some point.
Yeah, there certainly could be some academic studies where this data can be helpful, similar to what the feds have. I mean, the difference with the federal data is that it takes a higher level of it. You know how many of these cases were charged. It's harder to identify the specific cases, the specific defendants using the federal data.
Yeah. And I guess the only other comment I can make about the Hidalgo story is I'm not surprised to hear Susan Corey's name associated with it, because she's great. And little Doug Passon trivia, my first murder trial as a baby public defender in the late 90s was with Susan. I was her second chair. She's great to work with. Susan's amazing. But I know she was involved in that litigation too, so that's amazing.
Well, and the irony of it was that I was there the day we went to the trial judge with dollies of banker boxes full of these cases that we had identified and rolled them in to the court to have a hearing on it. And the judge waved us off and said, basically, I don't want to dive into all that. I mean, he was looking at dozens of banker boxes. I don't want to do that. I'm not going to overturn the Arizona death penalty on this basis. And so that started, the appeals process all the way up to the Supreme Court. When it got to the Supreme Court, they said, wait a minute, there was never a hearing. This data has never really been vetted undergone the kind of scrutiny that should have been done at the trial level. We were denied that opportunity, and the Supreme Court rejected that Hidalgo case because of the denial of that opportunity. So this case is still kind of being fought out there. There's efforts in Arizona to narrow the number of aggravators. A few of them have been struck by the legislature. Not many. It hasn't really changed a lot from my perspective, but that's kind of what happened.
All right. Well, this be a good time to talk about the very interesting voter cases. We've got set the stage for us, because we know voter fraud is in the zeitgeist. It's a hot topic right now. It's mostly an imaginary thing, I think, but you had some real cases. So tell me about those.
Yeah, it's I wound up working on two cases involving charges stemming out of the 2020 election. And as we know, the Arizona Attorney General, Mark Brnovich, was very much in the he had feet in both camps of election denialism and others. He was trying to pander to the true believers while he was considering and while he was running for the U.S. Senate as the Attorney General. So in my mind, as an outside viewer, a lot of these were politically driven. But there were legitimate cases brought against clients. And so I was asked to look at what the outcomes were of voting related cases, because there's just not a lot out there.
Yeah. Well, tell me, before you do that, though, when you say legitimate cases, what's the story behind these cases?
Well, there's different kinds of cases. One of them I worked on was the ballot harvesting case down in Yuma, where the Arizona legislature had, in I believe 2016, had decided that it would be illegal for people to go around and collect other people's ballots and drop them in the ballot box, and certainly a time-honored tradition, if you will, in lots of jurisdictions that aren't necessarily nefarious, but there's the opportunity to steer voters in one direction or fill out their ballots for them. So there was a statute passed that made that illegal, and some activists down in Yuma were caught by other activists doing just that for the 2020 election and got prosecuted for it.
But just to make sure I understand, is the crime, so the crime isn't necessarily doing anything nefarious beyond just taking their ballot and dropping it off for them?
Somebody else's ballot.
Okay,
correct.
So they're acting like a mail person or a UPS person, but that's not legal under this statute.
Correct.
That's right. But that's the extent of the evidence against them in this case.
That's right. I mean, they found the ballots and determined they were not relatives. You can take your spouse's ballot in or your child's ballot in, somebody that's related to you, but you can't take somebody else's ballots and deposit them. And we had all those vigilantes out watching those drop boxes, and that's what they were looking for. They were looking for people who were putting multiple ballots into a drop box, getting out of their car and putting multiple ballots in, and then having a nosebleed when they saw that. But there's nothing necessarily illegal about dropping multiple ballots, because you can do that for your family members.
Yeah.
So it was, we wound up with a lot of voter intimidation matters that were alleged during that part of the process.
Yeah. People all over the country saw those images from Arizona of the masks and the sometimes armed.
Yeah, wearing camo and confronting people. Yeah, it was crazy.
Welcome to Arizona, everybody. All right.
Yeah. Hey. So the other kinds of cases that we found, I did a study on everything that I looked for all cases that were charged under Title 16, which is the election process. So I was able to do kind of a global search for cases, because when I do these searches, it's based on statute numbers. And so I can narrow those things down to everything in a particular title. And so I looked statewide, and I identified about 70 cases covering 20 years. And most of the cases that were in the past were people that were basically snowbirds in Arizona, and they were voting in 2 jurisdictions. So there was a bunch of them that were voting in Arizona and Colorado, for example, and other states. So, and they got caught in the process of doing that, and they got prosecuted. The other case in Maricopa County that I did for the 2020 election, there were similar cases around the state where people would cast the ballots of a recently deceased relative. My, spouse died 2 weeks before. I know she wanted to vote, and so I filled out her ballot and voted for her, because that would have been her last wishes. There was a half a dozen cases of that kind of voting. A lot of the other cases are people who had not had their civil rights restored and were voting. For the 2020 election, they found, I can't remember, 5 or 6 people who were actually inmates in the Pima County Jail down in Tucson, who were casting their ballots from jail. And so there's others who have been casting ballots for years, thinking that they had their civil rights restored, and it turned out they didn't. And so those were mostly what the kind of prosecutions were. Other kinds of cases have found under Title 16 had to do with campaigning. It might have been forged petitions, campaign finance violations, all those kinds of things that come out. But where individual voters were being charged, it was typically voting in multiple states, voting for a deceased relative, and not having your civil rights restored. So those are typically, and then of course there was just the one example of ballot harvesting, because it was a new statute, and this was the only person who had ever been charged under that. But if you look at all those cases,
well, wait. So now I'm super curious. Just what's the party breakdown? Do you know that? Like, which side of the aisle is doing this?
Not really. I didn't. I know what it was in the cases I worked on.
Okay.
But the court record on the other cases don't go into that. And I can tell you, in the cases I worked on, that it was one of each. It was one party and the other.
Okay.
What stood out to me in the 2020 stuff was that the number of cases that were brought. Brnovich created this election integrity unit, and so that was their focus. So there was a dozen or more cases that were charged out of that election, versus 2 or 3, maybe up to 5 in other election cycles prior. So while there's been prosecutions in virtually every election cycle, it's usually less than 5. And after the 2020 election, it became double digits. And so that was kind of part of it. But then you start looking and you say, look, what were the outcomes of all these? And in virtually every case, these were all resolved as they were charged as class 3s usually. And
tell me more about class 3 for somebody who doesn't know Arizona.
Yeah, Arizona's charging scheme goes from a 1 to a 6, 1 being the worst, 6 being the least, and that's so class felonies. 1 felony will be like a homicide. Class 6 will be some low level type of crime, and a class 6s are eligible to be converted if they're if the sentencing court says it's a designated class 6, it stays as a felony. If they make it undesignated class 6, then it can be reduced to a misdemeanor upon successful completion of probation. Most of these cases were either sentenced as misdemeanors, even though they were charged as felonies, they were resolved as misdemeanors, or they were sentenced as class 6 undesignated and subsequently reduced to misdemeanors. No one went to jail in any of these cases. And so when I testified about these at the time when I did the study, I testified to that effect because the Attorney General was asking for jail time for both of the defendants. In the ballot harvesting case, they wanted a year.
Wow.
And in the dead spouse voting case, actually it was a dead mother voting case, the woman cast her deceased mother's ballot. The woman had just died before the election. And in that case, the state wanted 30 days in jail. And the judge from the bench after in our sentencing hearing said that cited the study that I did and said it would be unfair to sentence this defendant to jail when nobody else similarly situated goes to jail. And so,
and by the way, why is dropping off a legitimate ballot for somebody else warrant a year in prison, where literally voting for a dead person warrants 30 days?
Yeah, there's, those are the kind of discrepancies that are rife in the criminal justice system.
Yeah. Okay.
There's no logic. These laws that are and sentencing schemes that are passed by legislators, are done for political reasons, and defendants wind up being the beneficiaries of all of that politics. And we see it going on at the legislature right now in Arizona. All the crazy bills that are down there, and mandatory sentencing and all that kind of stuff is the kind of stuff we see all the time.
I'm starting to think I need to relocate to like a really liberal state like Florida or something like that.
Yeah, good luck with that.
Oh my
Yeah.
God.
Just
How old
don't
was
take
this woman, this mother, this grieving mother who cast this dead person's vote that they wanted to send to jail for 30 days?
Yeah, she's in her 60s.
Oh,
And her
oh my
mother was
God.
in her 80s when she died. Yeah. Yeah.
Oh my goodness.
Right.
Okay. So
So
basically you're looking at all these pre 2020 cases where before election fraud became the hot button topic du
du
jour.
jour.
And you're
Yeah.
saying
Yeah.
nobody's going to jail over this.
Right.
And
Right.
a judge looks at that and says, yeah, nobody's going to jail and these two aren't either.
Right.
Is that right?
Yeah.
Okay.
I
That
mean, there
tells us
was
what we need to know.
no, take that back. The ballot harvesting case did go to jail. That was in Yuma County in front of a judge, and there was a lot of political pressure. There was the courtroom was packed with Republican activists, GOP activists, calling for this woman's head. Basically, it was the same people who had videotaped her dropping these ballots were right there in the courtroom. This is an elected judge. In Arizona, the rural counties still elect their judges, and this was an elected judge looking out at prospective voters who were very vocal. That's my interpretation of it.
Yeah.
But it did give her 30 days in jail, which was, the state wanted a year, but he did give her 30 days. So she did a 30-day sentence for that ballot harvesting case.
Wow.
Yeah.
Yeah. That's
Now,
another.
other people, in the study, they did jail sentences, the ones who had violated their civil rights, but every single one of them was already serving a jail sentence for something else. Several of them were in prison. One was there in prison for arson and was already serving a 20-year sentence. And so they was given a 1-year jail sentence on the voting thing, concurrent to their current case. So it's kind of, doesn't mean anything.
Yeah. Amazing. Interesting. Wow. Okay. So yeah, I think that's the other little takeaway here is the difference between state and federal judges. And a lot of states are like ours, and they have to answer to the voters. In federal court, they're appointed for life by the president, which means many of them have zero. Well, I mean, they're always concerned about the public perception. I think that's a big takeaway. Judges want to do the right thing, and they care about sentencing parity and all that. I'd like to think, but it's a whole other level when you're
in the cases I've testified in. I've gotten mixed reactions from judges about this stuff. Some of them, I remember one judge in particular just sort of was dismissive of it all, saying, look, I know what outcomes are on these kinds of cases. Nobody needs to tell me those things. Nobody's going to tell me that I have to do this or that. I can make my own decisions. However, what I've noticed is more judges seem to run for cover behind these things, saying, look, this gives me a justification that I can hang my hat on, and I'm not abusing my discretion. And I'm being fair to everybody. It's kind of like the Judge Gersh thing. They wanted to do the right thing, and it helps them in their decision making as to what's the right thing to do in this particular case when they see it in the context of other cases.
Yeah, I love it. And I guess from my mitigation storytelling perspective, I'm a firm believer that a good story well told can impact the sentencing. And I suppose I'm just curious, have you ever come across, when you're looking and you're doing that deep dive and there's an anomalous result, hopefully a low sentence or maybe a horrible sentence, do you see like, wow, there was a big gaping hole with either a really amazing piece of mitigation that was developed by the team or a lack thereof? I mean, do you have a perspective on that part of it that's informed by this?
Yeah, I haven't done a dive to look and see how the defense put together their presentation or whatever. The sentencing memorandums tend to be where that stuff shows up, and ones where they do a thorough job of crafting a sentencing memorandum about their client, and that's where they put my study in, for example. So a sentencing memorandum or a sentencing presentation can include all those things about my particular defendant and my defendant in the context of everybody else. I think that's mainly where I've seen the benefits.
Yeah, good. Well, that's a good takeaway. Please, lawyers, file good sentencing memorandum. I've had a case or two in my day where I've tried to kind of give the lawyer some advice about a sentencing memo, and they said, "Well, we don't do those here." I said, "Okay, well, all right then. We need to do those." But man, this was amazing. I'm so glad we finally did this. I want everybody to check out R3 Investigations. .com. It's not just Rich. There's a whole team of incredible investigators there. They're based in Tempe, Arizona, right? Like I said, you're in another state, you're in another jurisdiction. You may not be hiring Rich to do the legwork, but you probably want to check in with him and get some of this guidance. Yeah, awesome. What else did I forget? I will give you the last word. What else do we need to know?
Well, I just hope everybody kind of fights these public records issues, not just this kind of data, but one of my complaints about the defense community is that they tend to let those kind of cases be fought by the media. But from an investigator perspective, the only way I can help you as a defense attorney is to get access to public records. And I don't see the defense community stepping up enough to defend our access, not investigator access, but the public's access to government records.
Yes. That's and for those of you that need, think all the data and statistics aren't sexy, well, they're certainly useful. But if you want some sexy stuff, Google Rich, because you've seen him on Dateline a few times and a lot of high profile cases. There's Netflix stuff. Like, he's everywhere. So it's pretty cool. I'm going to have you back and we're going to talk about that and probably talk about Juan Martinez a little bit too.
Oh, there you go. Yeah.
But thank you so much, so much for coming on. R3investigations.com. Check it out. And we're going to talk soon. Thanks, Rich.
Enjoyed it, Doug. Thanks.
That's it for today. But before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today, getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon, Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.